Okay, we continue to take a look at the Senzo Meyiwa murder trial following the testimony of SAPS cell phone expert Colonel Lambertus Steyn. On Friday, he pointed out to accused number 3 as the person in the photo evidence that was beamed in court. And today, the legal counsel of accused number 3 going in on the testimony of Colonel Steyn and actually cross-examining him to give distinctive features about how he was able to identify that the person in the picture is the person that is seated in court today. Legal analyst Tyrone Maeko joins us now to take a look at some of the aspects that we saw play themselves out in court. Tyrone, thank you very much for your time this afternoon. And so Advocate Mnisi was at pains to actually say that the descriptive narrative is an integral part of the witness's testimony, and so really trying to break it down and spending so much time in the description. Why is that so important?
Well, and I must admit I've not followed that part this morning, but generally what you try to achieve with witnesses is to sketch to the court what would have happened, because it's so easy for us most of the time to pick up things that happen in the media, and we all are fair, or we think we are with what happened because there's been so much publicity about it. But a court does not depart from that point. The court assumes that it knows nothing, and evidence has to be presented in detail, and only then can the court, and once it's been tested, cross-examined, then the court can then accept what is credible, what's not credible, what it can accept as fact, and what is not fact. And so that's why you go through this painstaking process of the admission of evidence, as it were.
Okay, let's take a look. Listen at that moment.
Why do you say the person that is appearing on the photos is accused number 3? How do you recognize him?
By identical points, like I mentioned, the nose, the lips, the cheek here, the ears. I can.
Njengoba sengishilo-ke ngeimpawu zomazisi wakhe-ke ubani uma umbheka lana ebusweni uyakwazi ukubona umlomo, ikhala, amadlebe, konke nje okwakhe nje okusebusweni ngiyakwazi ukuthi nje ngimbone ukuthi uyena.
What about his nose?
Come again?
What about his nose?
The way his nose is the same as in the photo.
Ngendlela ikhala lakhe lingakhona manje liyafana nangendlela ikhala lakhe libuka ngakhona kulezi zithombe.
What about his ears?
It's the same.
Namadlebe nje kanjalo ayafana.
I guess you'll say the same thing about his eyes.
No, I didn't mention eyes now.
Azange ngikhulume ngamehlo ke.
What about his eyes?
Can you see his eyes, the color of his eyes there? I can see the color of his eyes now if he's not looking down, but he's looking for me sometimes.
Tyrone Maeko, Advocate Mnisi took his time in trying to get the description, but he also then mentioned when the state took exception to him laboring the point and said, well, the person in that photo is accused number 3, but what the witness failed to tell the court is the descriptive narrative that the accused has a different alabaster of a skin complexion, which he says looks like that of Colonel Steyn, going as far as saying that the only difference is that Steyn is Caucasian and this is an African male. Where do you see him going with this line of questioning? What is he trying to draw out?
You know what to do? It's very interesting to me, and sometimes lawyers, advocates, representatives of accusing court will do this. And I always ask this question. When you are in the art of cross-examination, is not trying to trick you at every step. You got to establish from your client what their case is, what their defense is, and then you proceed from there. So the question essentially here is, are the accused or any one of them disputing that they were in the house, that they're the people who have been identified as such? Because if that is the case, then essentially what you're doing is you cross-examining on the premise that the evidence that's being given, which is linking your client, is actually not reliable because that is not your client. But that, as I said, is premised on your defense being that your client was not there and the person who's been identified has been identified incorrectly. Because other than that, it becomes a waste of time to engage in this exercise if you are not disputing identities. And sometimes it's difficult for the court to interject, but I always feel that it should at this stage say, well, Mr. Mnisi, clarify, is it your case? Is it the case that that's not your client? Because you cannot then come later on and make an admission that actually the identification of your client is correct, that is in fact your client, because then you would have wasted the court's time going down this rabbit hole.
Mm-hmm. The court has been intervening. Let's take a look at this moment.
Why do you say the person that is appearing on the photos is accused number 3? How do you recognize him?
By identical points, like I mentioned, the nose, the lips, the cheek here, the ears. I can.
Njengoba sengishilo-ke ngeimpawu zomazisi wakhe-ke okanye uma umbheka lana ebusweni uyakwazi ukubona umlomo, ikhala, amadlebe, konke nje okwakhe nje okusebusweni ngiyakwazi ukuthi nje ngimbone ukuthi uyena.
What about his nose?
Come again?
What about his nose?
The way his nose is, it's the same as in the photo.
Ngendlela ikhala lakhe lingakhona manje liyafana nangendlela ikhala lakhe ibuka ngakhona kulezi zithombe.
What about his ears?
It's the same.
Namadlebe nje kanjalo ayafana.
I guess you'd say the same thing about his eyes.
I can't say it's been taken. I only see the script there. Photo 0032 and the date.
Ngengikwazi ukuthi lesi sithombe sathathwa ngaleso sikhathi. Ngiyabona nje kubhaliwe ukuthi photo 0023 ne-date.
How do we verify on which date and what time was this photo taken?
My lord, if you ask the downloader tomorrow, he will do exactly what I'm doing now. He will go to the cruiser, go to the photo, and he will show you exactly the same now on this photo number 0023. If I got my laptop with me, I could have done it now.
Yeah, you said it's not compatible with
That's correct, yes.
I mean, really, we've heard that evidence. He's struggling with the compatibility of the two devices. Otherwise, he would show it to you now, that information.
So you know
the only person who can do it, because his device is the one that transported this photo. It's Sergeant Mabasa.
Yes.
So you're not in a position, in a sense, to tell us the date on which and the time at which that photo on page number 46, as you're saying, was taken.
I can do it, but I'm not in a position to do it now.
Tyrone Maeko, this witness, did they come to court prepared? Yes, his equipment is not compatible with what they have in court, but this is something he knew on Friday already.
Yeah, I mean, these are gremlins which are annoying. These things shouldn't happen from a professional point of view. This is court and you're dealing with a very serious case, a charge of murder. And you think that you take your time prior to, and the state, that's the state's witness. So really the onus is on the state to ensure that it can present the evidence in a manner which is acceptable to the court and to assist this court in this regard. So these things can be solved by simply, do preparation, come to court earlier, even if it's a day before, it doesn't really matter, Friday, set the equipment up and make sure that it works all right. So if I were a presiding officer, I'd be very, very upset and irritated by this. It shouldn't happen. But as I said, these are housekeeping things that should be sorted out prior to the start of court.
Just finally, Advocate Nisi put it to the court that this trial is about identification of so-called intruders on the 26th of October 2014. And he says it would be unfair to approach the defense in a piecemeal fashion, looking at the judge as he was saying those words this after he intervened. What should we understand about that moment?
Yeah, I'm not sure I quite follow that. I mean, because the case is about a lot of things. I'm not sure that it's also just about identifying them. I mean, what the critical question here is, we know for a fact that there was a shooting, someone was shot dead, and there may have been, in the evidence that we've seen, more than one person in that house, assailants, let's call them assailants at this point. The question then is, if one accepts those facts, then yes, the identification of who the parties were, that becomes a critical point, a critical issue, because it's not in question that there was a shooting and how Senzo died. The question is, well, who did it? It then depends on what the defense of the accused is. Have they pleaded, or is it their defense that they were not there at all, and that even if there were assailants in the day, it could not have been them or any one of them? If that is the case, then yes, your focus would be, as defense counsel, would be in extricating your client from that house on the day, to say, well, you got to positively identify my client and place them at the scene. If you're not able to place them at the scene, then they could not have done this. And I guess that's what Advocate Mnisi is driving at, is to say it has to be shown beyond reasonable doubt that accused 1, 2, 4, 5 was not at the scene at the time and could not have been at the scene at the time. And in that case, you would have created doubt, and your client would most likely be found not guilty.
Thank you very much, Tyrone Maeko, a legal analyst.